Welcome, everyone, and congratulations on your new role as a manager at the JMMT Manufacturing Company. My name is Rosalind Trum. I am the Vice President of Human Resources. Today, we will be going over employment law for managers. Knowing the basics of employment law is essential for success in your new role. But first, the why. I was always the possibly annoying child who needed to know the why behind things. This trait followed me into my adult years and into my role as a manager. I find that once people know the why, they can adapt to company rules and initiatives with more enthusiasm. So I always tried to break these things down for my team. This practice led me to success with employee management in my role, and I hope it will lead you to success in your role as well. Employment law, most simply, is important for company and employee protection. Ensuring we are compliant with federal and state labor laws will protect the company from potential legal risks, save us money on the costs associated with lawsuits, fines, and conflict resolution procedures, and it also protects the company's reputation. From an employee standpoint, labor laws protect their rights as workers, prevents discrimination and harassment in the workplace, saves employees money on costly lawsuits, and helps provide them with a safer and more positive work environment. A safe and positive work environment doesn't just happen. It is cultivated from the ground up, and you, as our managers, are our first line of defense and compliance. Your actions directly impact the company's legal standing and work environment. By understanding and applying employment law, you will be able to handle complex workplace issues if and when they arise. With that said, let's dive in. The key laws that we will be discussing today include the National Labor Relations Act, the Equal Pay Act, Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, the Fair Labor Standards Act, the Occupational Safety and Health Act, the Family and Medical Leave Act, and the Massachusetts Paid Family and Medical Leave Act. Combined, these laws give us the framework needed to address almost any situation that may arise. The National Labor Relations Act of 1935 was enacted to balance the power between employees and their employers. It gives employees the right to organize and enter unions and provides them with a voice in the workplace. Unions aim to help employees advocate for their rights, improve safety regulations, and provides employees with fair compensation for their work. It also bars employers from interfering with organization attempts and union activities while banning retaliation against employees who choose to do so. Since 1935, legislation has continued to evolve. As you will see in further slides, there are far more protections than there once were, and the need for unions has lessened as companies have adapted to new legislation, improved human resource strategies, evolved benefits packages, and increased employee engagement. Still, there is a possibility that union interest may arise in the workplace. Signs of union activity include distribution of union-related materials, increased employee meetings, increased interest in policy and grievance procedures, and union-related questions. While unions are great resources for some workers, we would prefer to maintain a work culture that can adapt quickly to change and that encourages a cohesive employee management relationship. If our workers were to unionize, change in the workplace would rely heavily on a negotiation process that only happens once every few years. This would limit our ability to adapt to employee feedback, implement fun team incentives and bonus programs based on business needs, and could create an us versus them mentality between employees and management. Additionally, a unionized workforce comes with higher labor costs, legal expenses, reduces our autonomy in scheduling and promotions, and reduces our ability to adapt to the competition and can result in a disruption in business. Under no circumstances should you express negative comments or warnings to employees about union activity. These comments could be perceived as threats, coercion, or as violation of employee rights. Instead, bring this information to the attention of your supervisor and HR team so that we can get involved. As managers, the most important thing you can do is create a work environment where employees feel comfortable approaching you and trust you to have their best interests in mind. If an employee comes to you with a need, safety issue, or request that is important to them, make them feel heard by promptly taking action to address the situation. If you suspect union activities are taking place, simply reach out to your supervisor and HR team so that we can proactively address any concerns employees have. Let's work together to create a positive work environment that listens to and meets the needs of our employees without delay and without the need to get a third party involved. Now, let's go over some other important labor laws. The Equal Pay Act of 1963 was enacted to ensure fair compensation to all workers, regardless of sex. This requires employers to pay all genders an equal wage for equal work. The Act does allow for differences in compensation based on legitimate reasons, such as merit, seniority, education, experience, or performance metrics. Your responsibility as a manager is to make sure pay decisions are made fairly, without bias or discrimination. A common theme in this presentation will be the emphasis on documentation. Again, the why. Why did you grant this candidate a higher pay rate than another? What qualifications did the candidate have that led you to this decision? The more documentation you have on file, the more the company can justify decisions should an employee file a complaint. Human Resources generally helps guide you through these decisions, but should you have any questions, don't hesitate to reach out to your direct supervisor or the Human Resources team for guidance. Title VII of the Civil Rights Act is one of the most essential employment laws. This ruling prohibits discrimination against members of any protected class and went on to define these classes. As they stand today, they include race, color, religion, national origin, and sex, which now includes sexual orientation and gender identity. As managers, your role is to ensure that all business decisions are free from bias related to these protected classes. This includes hiring, promotions, discipline, terminations, and more. Again, documenting reasoning behind business decisions is crucial to understanding the why should these decisions be questioned. By understanding and applying these principles, you help foster a safe, positive, and inclusive work environment. The Age Discrimination and Employment Act prohibits discrimination against employees that are 40 years old or older. This includes protections against unfair treatment in hiring, layoffs, promotions, terminations, and other employment decisions. A common form of age discrimination involves targeting older employees that earn higher wages due to long tenure and seniority and replacing them with younger, lower-paid employees. Forcing older employees into early retirement or limiting their advancement opportunities can be violations of this law. As a manager, you are responsible for making sure decisions are based on performance, qualifications, and business needs. Avoid assumptions on employee capabilities, such as their ability to learn new technology, or assuming they have lower stamina, speed, or the strength needed to complete tasks. The Americans with Disabilities Act of 1990 prohibits discrimination against qualified individuals who have physical or mental disabilities. A disability is an impairment that limits one or more significant life activity. It is important to note that many disabilities are invisible. This can include neurodivergent employees, such as individuals with autism or ADHD, learning disabilities, mental health conditions, and more. The Act also requires employers to provide reasonable accommodations when at all possible. As a manager, you are responsible for handling accommodation requests with confidentiality and empathy. Reasonable accommodations may include providing assistive technology, modifications to the work environment, such as noise-canceling headphones, adapting work schedules, and more. If an employee approaches you requesting an accommodation, reach out to your human resource team immediately so that we can work together to find a solution that works for the employee and the company. It is important to note that employers do have the legal right to discriminate against a protected class only in the event that there is a bona fide occupational qualification that cannot be met by the employee. These exceptions are exceedingly rare, but not unheard of. Some examples of bona fide occupational qualifications are jobs that have specific lifting requirements in order to do the job safely, mandatory retirement ages for pilots and drivers to ensure safety for passengers, a role that requires a bilingual candidate, such as a Spanish teacher, or needing a male nurse to handle male patients in a facility. Again, reach out to your supervisor and human resources team to discuss situations that may qualify as a bona fide occupational qualification rather than making comments or decisions that could potentially violate an employee's rights. Sometimes situations require an in-depth analysis to determine if an accommodation can be made. In other cases, an employee might be able to be moved to an alternative role that they will excel in rather than jumping to termination or rejecting an applicant outright. Continue to document your reasons behind any decisions that are made. The Fair Labor Standards Act of 1938 set legal standards for minimum wage. Here in Massachusetts, the minimum wage requirement is $15 per hour, which differs greatly from the federal standard. It also established rules for overtime. Employees are paid 1.5 times their normal wage for every hour worked over 40. It is your responsibility to ensure accurate timekeeping and to manage the schedule efficiently. You can never ask an employee to work off the clock. The Occupational Safety and Health Act, better known as OSHA, is an important law that gives employees the right to work in a safe and healthy work environment. Employees have a right to know about potential workplace hazards, and they also have a right to receive proper training on identifying and avoiding these hazards. It is your responsibility to maintain a safe work environment by conducting regular safety inspections, discussing safety and having safety training sessions with your employees, and addressing any hazards or concerns that arise. If an employee points out something that they feel is unsafe, work with your team to address it in a timely manner. Remember to document trainings and conversations you have with your employees, safety inspection results, and hazards that have been identified and addressed as they occur. The Family and Medical Leave Act provides employees with job-protected, unpaid leave for up to 12 months. Qualifying events include the birth or adoption of a child, the addition of a foster child, leave to take care of a sick family member, and employee illness. You will be responsible for handling leave requests and helping to facilitate the details. You should never say or do anything that may seem like retaliation against an employee for requesting or taking leave. You should maintain confidentiality and express appropriate empathy or excitement for the life event that the employee is experiencing. Make sure you use your resources to manage the schedule and cover their responsibilities until their return. After a leave of up to 3 months, the employee will be returned to their same position or a comparable role without reduction in pay. You may not ask an employee who has returned from leave to work extra hours or to take any other action that can be viewed as retaliation. We should always do everything in our power to support employees when they are going through a major life event. The Massachusetts Paid Family and Medical Leave Act expands on FMLA benefits for Massachusetts workers. Employees are eligible if they have earned at least $6,300 or more in the last 12 months, have worked at least 16 weeks in Massachusetts, and there is no waiting period for eligibility. Please note that commuters from Rhode Island and New Hampshire are eligible for benefits as long as they meet this criteria. Employees are eligible for 12 weeks of paid family leave, 20 weeks of paid medical leave, or 26 combined weeks of leave in a benefit year. A benefit year is 1 year starting on the Sunday before the employee's leave starts. Employees are now able to top off leave benefits by using their vacation and sick time, though they cannot be forced to do so. They also can't be asked to take their paid time off before they can use PFML. As discussed on the FMLA slide, managers should handle these requests with confidentiality and empathy. Earnings questions can be directed to payroll, but employees can expect to earn about 80% of their standard wages without topping it off. This has been an overview of the key labor laws that are essential to your role as a manager. By understanding the basics of these laws, you will be able to foster a safe and positive work environment for your team. For more information, continue your manager training series, which will provide in-depth training and examples on how to apply these laws in areas like interviewing, hiring, safety in the workplace, and more. You can also consult the employee handbook as well as the resource links I have provided at the end of this presentation. If you have any questions or need support, don't hesitate to reach out to your supervisor, designated HR team, or myself. Thank you and congratulations again on your new role as a member of our management team here at JMMD Manufacturing Company. I wish you all the best.